This sentencing hearing starts in the middle of absolute frustration, and you can instantly tell this judge has reached her limit. Before the case is even formally introduced, she's already talking about how people could have been killed and calling the defendant's behavior a danger to everyone in Jefferson County. That's never a good sign for someone waiting to hear their sentence. Now here's what makes this case especially intense. The defendant, Mr. Toren, isn't just facing one felony. He's facing two separate charges tied to theft and a dangerously reckless attempt to evade police in a vehicle. Prosecutors say this wasn't some minor traffic stop where someone panicked and sped away for a few seconds. According to the court, this chase involved near collisions with innocent drivers, crashing through a fence, and continuing to flee even after wrecking the vehicle. The judge later describes it as behavior that could have gotten people killed. But the defense is trying to paint a very different picture. They're asking the court to consider his declining health, vision problems, mental health struggles, and long-term substance abuse issues. They even bring up supportive family members who showed up to stand beside him during sentencing, and that creates the big question hanging over this courtroom. Is this a dangerous repeat offender who refuses to change, or someone whose addiction and mental health problems completely took control of his life? The prosecution, though, is about to hit hard with one devastating point. They claim the only times Mr. Toren stopped committing crimes were the times he was locked behind bars. And once the judge starts reviewing his criminal history, including what she calls his 11th and 12th felony offenses, the tone in this courtroom changes fast. You can almost feel the possibility of mercy disappearing minute by minute. Stay tuned, because the details of this police chase are wild. The judge's reaction is brutally direct. And by the end of this hearing, there's absolutely no doubt how seriously this court viewed the danger to the public.
And this is cause numbers 25 DCCR 0974 and 25 DCCR 1152. Mr. Toren was previously in court, entered pleas of guilty to attempt to commit theft of property. It was enhanced to a second degree because of priors, and then evading arrest or detention with the vehicle, also enhanced to a second degree. I've received the pre-sentence report, and the agreement was for a cap of 20 years. It looks like it probably could have been habitual, but you guys pled it to just a straight second degree with an open plea to the second, correct?
Yes, ma'am.
And I've received the pre-sentence report as well as some documents that Mr. Radford has sent in with regard to Mr. Toren's mental health as well as some physical issues, and one letter as well of support. Have you both had an opportunity to review all of that?
Yes, ma'am. Yes, Judge.
Are there any additions or corrections to that pre-sentence report?
Just the things that I submitted, Judge.
Okay, Mr. Radford, you may proceed.
Judge, Mr. Toren has an extensive criminal history. However, as he has gotten older, he has had some health issues. He has vision problems. He has been seen and treated at Spindletop MHMR for some mental health issues. He has a very supportive family who is here today, and I'd ask that the court take that into consideration in determining his sentence.
What is the status of parole?
No, we're waiting on the way.
We're waiting on this.
Okay.
Mr. Smith?
Judge, his extensive criminal history going all the way back to his juvenile years tends to show more about what he is and what he does than anything else. He's been given probation. He wasn't able to complete that. He has been sentenced to multiple long sentences in prison, and that seems to be the only thing that has kept him from committing new crimes in society, was the fact that he was incarcerated. I don't feel like probation is appropriate. We would ask for, we have given him consideration by coming off of the habitual and capped this at 20 years. So we would ask.
At this point, the prosecution has laid out one of the toughest arguments a defendant can face during sentencing. The idea that rehabilitation has already been tried and failed repeatedly. Notice how the prosecutor keeps emphasizing the defendant's long criminal history, failed probation, prior prison sentences, and repeated returns to crime after release. That's important because sentencing hearings are not just about what happened in this one incident. Judges are allowed to look at patterns of behavior over time, and in this case, the state is arguing that the pattern never changed. What also stands out here is the contrast between the defense and prosecution narratives. The defense is leaning heavily into mental health struggles, substance abuse problems, physical decline, and family support. They want the court to see a human being struggling with addiction and personal issues. But the prosecution is framing the defendant as someone who knowingly continues making destructive choices despite years of opportunities to change. And viewers are probably split right now. Some people hearing this may think the system failed to properly treat addiction and mental illness before things spiraled further. Others may believe that once someone repeatedly commits serious crimes after multiple chances, public safety has to come first. That's exactly why this hearing feels so tense. It's not just about punishment, it's about whether the court still believes rehabilitation is realistically possible.
We would ask for TDC sentence in the high range on this.
So, Mr. Torin, in 2019, you received a 15-year sentence. So you were only not, I don't know how long it doesn't show me when you got out or how long you were in on that, but obviously.
I got out one night of 23.
So you got out in 2023, and less than 2 years later, you've got 2 more felonies, which add up to your 11th and 12th felony offense. And I understand the issues with PCP. It looks to me like that's more of an issue than anything else. I understand there's some mental health issues, but you as a grown man have had every opportunity to get help and try to get in TDC, out of TDC, to live your life outside of prison, and you've chosen not to do that. I mean, your only time clean is when you're in custody. That's what you told the person doing that substance abuse assessment. I don't know. I just think it's I appreciate your family being here, and I appreciate the support, and I appreciate this letter, but it's all ridiculous when you look at your criminal history and the fact that you're on parole and you commit 2 more offenses and you're still using drugs, and you haven't it's not like you're a young kid. You know what you need to do to get the help you need to get. And you've made a conscious decision not to do that. So at this time, in cause number 25 DCCR 0794, and this evading was crazy. I mean, you could have killed people. You got used, I think it was twice you almost struck intersection of Interstate 10 and 7th Street, almost struck another vehicle. And then again at 7th Street and Dollinger, you almost struck another vehicle. You crashed through a fence. Then you continued to flee after you crashed through a fence and crashed again and finally came to arrest. I mean, it's not like you just kind of sort of evaded. Your behavior is just a danger to everybody here in Jefferson.
This is the moment where the judge completely shifts from discussing criminal history to focusing almost entirely on public danger. And honestly, you can hear the frustration in every word. The court is no longer treating this as a simple evading arrest case. The judge is describing a chain of reckless decisions that could have caused catastrophic consequences for innocent people on the road. According to the court, the defendant nearly struck multiple vehicles, crashed through a fence, wrecked again, and still continued fleeing before finally being taken into custody. That's why the judge says it's not like you just kind of sort of evaded. In other words, this wasn't viewed as minor resistance or panic. The court saw it as an extreme threat to public safety. What's especially powerful here is how the judge responds to the family support in the courtroom. Normally, judges appreciate seeing loved ones present because it suggests the defendant has people willing to help them rebuild their life. But here, the judge essentially says support means very little if behavior never changes. That's a harsh reality for everyone sitting in that courtroom to hear. And now, after reviewing 12 felony offenses, failed parole, continued drug use, and a dangerous police chase, the judge is making it clear that incarceration, not another chance at supervision, is the only option this court believes can protect the public.
County. So that being said, 25 DCCR 0794, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of an attempt to commit theft of property, find that prior conviction true, or the prior convictions true in that case, sentence you to a term of 20 years in the institutional division of the Texas Department of Corrections. And cause number 25 DCCR 1152, find also sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true, sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Correction. You will receive credit on each of these sentences for any time that you've been in custody that the law gives you the right to receive. I'm handing you, and they will run concurrently, which means together at the same time. I've handed you the trial court certification that shows these were agreements. I followed. You've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. Read that. You should already understand it. But if you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Radford. All right, you can go back with the bailiff.
By the end of this hearing, the judge sentenced Mr. Torren to 20 years for attempted theft of property and another 20 years for evading arrest with a vehicle. However, the sentences will run concurrently, meaning both punishments will be served at the same time instead of back-to-back. Even so, this was still an extremely serious outcome driven largely by the defendant's lengthy criminal history, repeated parole failures, ongoing PCP use, and the dangerous police chase that nearly put innocent lives at risk. The court clearly struggled with two competing realities in this case. On one side, the defense presented evidence of mental health issues, substance abuse problems, physical health decline, and strong family support. On the other side, prosecutors argued that years of probation, prison time, and opportunities for rehabilitation never stopped the cycle of criminal behavior. Ultimately, the judge sided heavily with the argument that public safety had to come first, and that's what makes this case so compelling to watch. It raises difficult questions about addiction, accountability, rehabilitation, and whether some defendants eventually run out of chances in the eyes of the court system. Some viewers will see this sentence as necessary protection for the community, while others may believe deeper treatment interventions should have happened long before things escalated to this point. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.